Hi, you're listening to the Lawyer Society Legal Podcast for lawyers, practicing advocates, law students, and judicial exam aspirants. Hi guys, in this episode I thought we'll be talking about one particular comparison between the CRPC 1973 and the new CRPC that will be coming into force from the month of July. This is regarding the concept of cognizance and a very curious little thing that is going to happen, a shift in the interpretation of the provision and its application in the courts. Let us first begin by explaining what cognizance is. Basically, cognizance refers to the idea of a magistrate applying his mind to the material placed before him, and you can view or visualize the same as him taking control of matters. As in, he receives the material, he sees there's some sort of an offense here, and I'm going to proceed, I'm going to see what comes out of it. And that is to the level to which he applies his mind. There is a very limited application of mind, but there is an application of mind, and he takes the material into his record, and that is called taking cognizance. So to summarize, the magistrate takes the file or material onto his record. That is called taking cognizance. So thereafter, he is the manager there. He is going to take care of matters. In this particular episode, we'll be talking only about cognizance in private complaint cases, which is you approaching the magistrate and giving a complaint, and he takes cognizance of the matter and proceeds with the trial. There is no police investigation, there is no FIR and all that. Basically, cognizance is taken under section 190 subsection 1 clause A of the CRPC 1973. So when you provide a complaint under section 200, he is to apply his mind, take cognizance. He examines the complainant and witnesses, if any, and in certain cases he doesn't have to examine the complainant or witnesses. And thereafter, let us just skip section 201. Under section 202, if he feels he needs more material, he wants to collect certain data, he will inquire into the matter himself, or he will be directing the police to investigate. So to be very precise, the police investigation directed under section 202 of the CRPC is not the same as that which will flow from the registration of a FIR and culminate in the filing of a police report. The investigation under section 202 has very limited scope, and the same has been established by the Supreme Court in several cases, and I will explain that in a different episode. We'll discuss that in a different episode. After section 202, there is section 203 where the magistrate dismisses a complaint. He will be considering the statements by the complainant, the witnesses, if any, and also the material he was able to gather under section 202. And overall, if he feels there is no sufficient ground for proceeding, he will say, okay, I'm dismissing this complaint. Or if he feels there is sufficient ground for proceeding, then under section 204, he will issue summons to the accused person. So as you can see, the accused person has a role only from section 204. Before that, there is no mention of the accused person. Let me tell you very briefly that if a complaint is being dismissed under section 203 and the complainant files a revision petition before the Sessions Court or the High Court, in such case, it is mandatory for the court to hear the accused person or the suspect named in the complaint. This was held so by the Supreme Court in the case of Manharibhai, Muljibhai, Kakadia versus Shaileshbhai, Mohanbhai, Patel from the year 2012. This case is reported in 2012 10 ACC 517. So there are only two scenarios where the accused person is to be heard. One where the complaint is being dismissed and the same is being challenged by the complainant. The other is after issuance of process. Right now in the new CRPC that is about to come into force, we have a proviso attached to section 223, which is the corresponding provision to section 200 of the Code of Criminal Procedure 1973. So as per this proviso to section 223, the accused person must be given an opportunity of being heard before the magistrate takes cognizance. The proviso reads, provided that no cognizance of an offence under this section shall be taken by the magistrate without giving the accused an opportunity of being heard. So the bare reading of the same suggests that the accused person is being given an opportunity of being heard, and it looks to be mandatory because there is no exceptions that has been provided under this proviso, say where there is no accused person named in the complaint or there is no suspect. You can imagine various cases where the accused person will not be named in the complaint, or the magistrate will not even be able to decipher who the suspect is. There are multiple cases where you will have such a scenario, and to say that the magistrate has to hear an accused before taking cognizance is actually against the established practice or established law that has been existing for over 100 years now. Let me just quote a judgment from the year 1986. 1986. This was rendered by the Rajasthan High Court, a full bench of the Rajasthan High Court. The cause title is Mahesh Chand versus State of Rajasthan. The question before the High Court of Rajasthan was whether an accused person has to be heard before taking cognizance. Here it was said that even in private complaint cases, there is a possibility that no accused person will be named in the complaint. It is not possible that you can hear the accused in all cases before magistrate takes cognizance. Thus, it is not necessary that an accused person must be necessarily heard before taking cognizance. The same was followed by the Allahabad High Court very recently in the case of Alok, Gupta versus State of Uttar Pradesh. I will leave the citations in the description box below. So as you can see, it is an established practice in law that an accused person has no role to play at the stage of cognizance. Right now, in the new code, we have a very weird scenario that the accused person is being given an opportunity at the stage of cognizance, and also the other provisions, which is the ones corresponding to section 203, 204 are all intact, which means you are hearing the accused before taking cognizance, and also if you are deciding there is sufficient ground for proceeding, you are summoning the accused once again in the provision that is corresponding to section 204 of the present codes. It is like you wanted to insert a proviso and give an opportunity of hearing to the accused, but you have not changed the other provisions to make sense out of it, and also you have not provided any exceptions to when the accused person or the suspect persons are not named in the complaint as such. I don't know if this will lead to any trouble as such, but I can imagine a scenario where the magistrate will say, since there is no accused person named in the complaint, I am directing police investigation. Let me see a police report. Let me also give you a case where it was said that there is no need of a named accused person in a private complaint for the magistrate to take cognizance and proceed. This was recently established by the Karnataka High Court in the case of Shivakumar, son of Ningappa Sindagi versus Vijay Kumar. It is from the year 2022. I will leave the case number in the description box below. In this particular case, the Karnataka High Court had a chance of dealing with a similar scenario, and they had observed that there is no need or no mandate for the magistrate to direct a police investigation just because there is no named accused in the private complaint. He can take cognizance and thereafter figure out who the accused person is by making an inquiry or directing an investigation under section 202. So when there is a provision such as 202 in place, there is no compulsion for the complainant to name a specific person as an accused when he files a private complaint. Whereas here in the new code, there will be a very implied mandate that there should be an accused person named in the private complaint itself, which will cause a lot of confusion, and it can be predicted that this will lead to some trouble for the time being before the air gets cleared by a Supreme Court judgment or by the high courts in different states. I thought it's a very interesting topic to discuss today. In the subsequent episodes, I will also try explaining or comparing the two codes, or the new IPC with the old one, or the new Evidence Act with the present one. And also we will be having several other episodes where we discuss the issues we will commonly see with the new laws coming into force. If you like this episode, please do follow us on Spotify. Also, do consider subscribing to our monthly digital law magazine. If you're interested in subscribing to our digital law magazine, please do contact me on WhatsApp. My contact number is 98407-18196. You can also contact me through email. My email ID is lawyersocietyofficial@gmail.com. Thank you for listening. Stay tuned.